you interpret Constitution, especially when involved fundamental liberties. When it comes to fundamental liberties, the principle of interpretation is that the court must give a liberal and okay a prismatic interpretation, a liberal interpretation. Yep, right. So, and if you are a doubtful which way to go, you must all the court is obliged to rule always in favor of the citizens, not for the authorities, right? Right. That's one interpretation. The other thing is any law that restricts freedom of speech under Article 10, Clause 2, any such laws must pass the test of reasonableness. Yeah. And that was then decided by the federal court in the case of Siva Rasa. For the first time, the federal court, laid down the principle that restriction on fundamental liberties, pursuant to clause 2 of Article 10, restriction must satisfy the test of reasonableness, right? Okay. And I came to the conclusion that the law does not satisfy the test of reasonableness. And why did I say so? Why did I say so? First thing I find it's not even reasonable. It's worse than, it's not even unreasonable. It's worse than that. It's irrational, right? Irrational to say that university students cannot, express opinion whether in support or against the a political party. Let me read what's this one I wrote. I said in my judgment. In my judgment, I point out that the provision was frankly irrational on its face, and I said in my judgment, the impugned provision is irrational. Most university students are of the age of maturity. They can enter into contracts. They can sue and be sued. They can marry, become parents, and undertake parental responsibilities. They can vote in general elections. Yet, and herein lies the irony, that they are told that legally they cannot say anything that can be construed as supporting or opposing a political party. That's in my judgment, right? And I went further to say something about the purpose of universities. Suppose what universities are supposed to serve. I said, in my opinion, such a provision as Section 15, subsection 5, limb A of the UCA impedes the healthy development of the critical minds and ordinary thoughts of students. Objective that seeds of high learning should strive, and here's important, please listen to this, should strive to achieve. Universities should be the breeding ground of reformers and thinkers, and not institution to produce students trained as robots. Right? I repeat that part. Universities are universities should be the breeding ground of reformers and thinkers, and not institutions to produce students trained as robots. Yeah. So I accordingly declared Section 15, Subsection 5A of the UCA unconstitutional and void under Article 4:1 of the Federal Constitution. But there's something else that I would like to share with you all this afternoon. Something else. I also said in my judgment, I fail to see in what manner Section 15, subsection 5, limb A, UCCA relates to public order or public morality. I also do not find the restriction reasonable. I am at a loss to understand in what manner a student who expresses support for or opposition against a political party could harm or bring about an adverse effect on public order or public morality. Are not political parties legal entities carrying out legitimate political activities? Are not political leaders, including ministers and members of the federal and state legislation, member of political parties? That's what I wrote in my judgment. Yeah. There's something else that of interest that I want to share with you all this afternoon. You see, the Senior Federal Council for the UKM referred to the Hansard. What was said by the minister in 1971 masih nak membentangkan round undang-undang ini di Parlimen. Why they need to have Section 15, Subsection 5, limb A. So I look at the Hansard and I discovered something that is very interesting. Yeah. Because I find that something which the minister said cannot be reconciled with with the prohibition under Section 15, Subsection 5. This is what the minister said, masa membentangkan. The minister said, mereka meaning the students, juga merupakan bakal pewaris kepada kepimpinan negara. Okay? Justru, kebajikan dan hak asasi pelajar hendaklah sentiasa dipelihara dan mengikut perlembagaan persekutuan dan amalan terbaik. Best practices antarabangsa. Okay? So far, so good. This is the crunch. He says, the minister says, selain daripada itu, kementerian juga sedar bahawa masyarakat pelajar pada masa ini lebih matang dalam menangani erti kebebasan dan kepelbagaian. So the minister can say, student dah sekarang ni dah matang. Dan pandai menangani arti kebebasan dan kepelbagaian. And it is what the minister said in Parliament. Then why did you enact Section 15? So it doesn't, akta nak dibentangkan cakap satu hal, minister yang mengesyorkan cakap benda lain. So I don't know why. I think the Senior Federal Council tak baca kat before the tender. Aduh. Right. Okay. So that's my part, and then of course, Justice Linton made a decision also in favor of the students. So what's the score? 2 against 1. So those in favor of the student wins the day. So the student wins by one majority vote. So just made it, right? When I look at the expression on the facial of the council, I think they don't believe it. No. Huh? We can't believe that we won in this case. Yeah, they don't believe it. Yeah, but they won the case, right? So what happened then? Okay. It's very rare, that the newspaper reported in full judgment of the courts. But this time, the Star newspaper on three successive days reported our judgment in full verbatim, no summary. Yeah. First day, it was the full judgment of Justice Lahok Beng. Second day, it was full judgment of my judgment. And then third, the full judgment of Justice Linton. Right. So then uh, what happens next? As usual, the government appeal. The government tak boleh kalah kan? So the government appeals, right? So now there are two divisions in the Attorney General's chambers, right? One division is a drafting division that drafted, macam ni lah, macam akta ni. The other division is the civil division, that go to court and fight for the government. So it is the civil division that files an appeal, civil division. But they don't know what the drafting division were doing. The drafting division pula did the opposite. Drafting the division draft an amendment to the act to amend 1615A to give support to our judgment. Very rarely, yeah. So this was a positive reaction on the part of the government. The government accept our judgment. So if you look at the bill, the government move to delete the offensive provision of section 15, subsection 5, lim A. Remove. And in the explanatory statement of the bill, the government says, we are amending section 15 in line with the judgment of the Court of Appeal in the case of Muhammad Ilham. Idam, right? Ilham, right? Ilham Idam. Thank you. But the other part of the AGC division doesn't know what this part doing. They proceed with the appeal. So the appeal was heard. The appeal was heard and came before the federal court. And came before the federal court pointed to them, what, Senior Federal Council, why are you appealing? The government has already amended the act, right? So of course there was some red faces lah. So what to do? So they have to withdraw. The appeal was dismissed. Appeal was dismissed. Yeah, it's overtaken by events. Yeah. So that's something very weird. Again, something very weird. Something very interesting. So I suppose that's my take on this question. I haven't been taking too long a time. Thank you for listening. Right.
Thank you so much, Judge. It's not every day you get to see the judge who write the judgment explain to you why he's writing the judgment. And there's a famous saying that Prof. Shad always say in class, context breeds content. So understanding the context behind the case makes you understand and appreciate the case better. Now, moving on to the next question, I think I'll pose to Inche Nazim first before we go to the practical part. So Inche Nazim, Inche Nazim kan? Yeah, Inche Nazim. Okay, we've discussed about Article 10 quite briefly. So I just want to ask, under Article 10, it says that you have a right to freedom of speech and expression. And a lot of cases tend to interpret it liberally. Do you think that is the correct way to interpret the provision, or do you think it should be a bit more restrictive in some cases?
It depends. Sorry. If you're pro human rights, if you call yourself defender of fundamental liberties, obviously you would want those provisions to be liberally interpreted. You would want the court to read into the principle, for example, like Datuk Shamrin said, the principle of reasonable restrictions. Yeah, but aside from that, because we keep on, we keep on telling our students, especially in when they do jurisprudence, here constitutional law, especially in for this particular fundamental liberties, constitutional law 1 is taught in part 4, in part 2, in semester 2. So in semester two, we just go around. Okay, what are the cases? What's the judgment? What's the ratio? Any obiter? Why do you which decision do you think is better, and so on? Okay, this is clearly black law, legal analysis. But once they get to part five, the semester five, they have to do jurisprudence or legal theories. So this is where we get into the issue of, so the court has given this kind of judgment. What is a guarantee that this court's judgment is supported by majority of people? This is another different area, because um, this is my this is what happened to me. Um, I was really looking forward to reading Dr. Shamuddin's judgment in 2011. Um, Dr. Shamuddin said this was fully reported in Star. We couldn't wait, so we went online, and some guys from Loya Buro uploaded the entire draft version of the judgment. Um, being a hot-headed person as I was in 2011, so I made a commentary about it. I went around the campus saying, this is nature of university. This is what students should be, and so on. Yeah, and I shared that opinion with some of my friends from other universities. But apparently, in that era, which was under Najib Razak, so there was this perception that fundamental liberties or human rights, these are airy-fairy areas which are not important. Even I myself, during that time, I was repeatedly advised by some experts that, Nazim, can you please concentrate on other areas of the law? What about company law, business law? I mean, constitution law, this is nothing. This is training students to become anti-government. I mean, that was the that was the sentiment during that time. So yeah, apparently there was this issue. Regardless of what the court says, clearly the majority judgment, Dr. Shamuddin's judgment, clearly pointing out, these are university students. They are adults. They could become company directors. They could be appointed the whole positions in all of the societies. They could get married, and you still have this provision against them. It does not make sense. I mean, clearly. So at that time I was thinking, was just could this judgment be made compulsory to officers handling students affairs in other universities? I'm not sure whether that has been the case, but I doubt whether officers in Hollywood Plaza in all of these universities have even read the judgment. Even if they had read the judgment, this is just a court's judgment, this has nothing to do with us. Because a few years later, I was invited to this workshop regarding students' disciplinary matters in one of the local colleges. So there was this guy. One of the rules in that college was that students, in order for them to assemble anywhere within the grounds of that particular college, they need to get a written permission from the head of the college. So I alerted to them. Look, there was already a case, a court of appeals decision in Nazmi, that in Nick Nazmin's case, the provision which made it on an offense if you do not send in the 10 days notice, that was declared as unconstitutional. So I advised them that, look, maybe you cannot penalize them for this. You have to respect their rights to assemble and so on. Oh, sorry. Hello. So the answer given by that officer was that, oh, that is the federal constitution. This is our college. Surely in our college we could do our own laws. That was it. I was like, you know, the federal constitution is the highest law of the land. You do know that, right? Yeah, but that's the federal constitution. Here in our college, we could enact our own laws. So what the law is, how the courts interpreted it, might not reach to the hearts of all of these people. And uh, and then I noticed something. Whenever you talk to all of these people regarding the concept of freedom of speech, the most favorite talking points to all of these people is that, oh, fundamental speech, fundamental liberties, they are not absolute. We cannot be like the West. This is Malaysia. We have our own laws, customs, and morals. Oh no, you cannot be absolute and like that. Or Bahaya liberalism and so on and so on. Like what? shouldn't you look into the nature or the significance of fundamental liberties in this? It is these fundamental liberties which make us human beings in the first place. None at all. So what is happening here? Am I supposed? Should I do something more than I'm expected? I can't do much. I'm just orang tua who teaches law. That's it. I don't. I don't have any other powers. I don't have any positions. Obviously, I'm not a Tan Sri as well as you guys know. So, what else should we do? So this is a problem for defenders and defenders human rights like me. I am, but at a certain point after reading all of these materials on fundamental liberties, yeah, I'm sick and tired of that. But at the heart of the matter, I am. And of course, I would want all of these provisions to be liberally, expensively interpreted. You could throw out all of these principles in constitutional interpretation to them, or the constitution must be liberally interpreted. You could, for example, quote them, in the case of Dato Osman Datuk Menteri Osman Baginda, a constitution cannot be rigidly interpreted. Judicial precedent plays a lesser part in constitutional interpretation as compared to statutory interpretation. Yeah, you could throw all of this at them, but they would not listen. That's the problem. Thank you.
Guys, I think such a insightful yes. I always thought there's only constitutional supremacy or parliamentary supremacy. This is the first time I listened college supremacy. Interesting. Okay, the next question will be to Ms. Farah. Encik Nazim say he's a orang tua who teaches law. Now as a orang muda who practices law. Ms. Farah, how do you think disputes involving freedom of speech arise in practice, a more practical term? And what are the common legal issues and challenges that lawyers encounter when advising clients on these kind of matters?
Thank you, Nishal. I think first of all, I would address the elephant in the room because I'm flanked by, a judge who has, like, former judge who has actually sat on an actual constitutional matter and actively also advising on human rights as in his capacity as the chairman of the Human Rights Commission. And on my other end, I have constitutional law lecturer whom I'm sure all of you are more familiar with and listen to his lecture. So what am I, a commercial disputes lawyer, doing here talking about constitutional law? So I told Nishal, look, what I can do is I can actually inject, perhaps like what Encik Nazim said, that constitutional law is not really it is really not an airy fairy subject. It is not something that only belongs in the textbooks. And why I say that is because I believe that constitutional law is not a separate island. It is really a foundation upon which every area of law is built. Most constitutional principles are actually developed in landmark cases, but they are applied every day by ordinary litigators, whether or not we realize it. So, my perspective may not be constitutional academic, but from a disputes lawyer who sees constitutional values tested in real cases. So, to me, Nishal, freedom of speech occupies a very unique place in our constitution because it enables our citizen to participate in public life. From litigation's perspective, constitutional rights, they rarely walk into a court by itself. So I was telling my pupil Afiq the other day, I say, as well as my intern Ismail, I say people don't really come, especially when you're practicing civil litigation. You don't get clients who come to you, daily and say, I want to sue someone or I want to take an action based on a constitutional issue. So we don't get that. They usually arrive or make their appearance with us wearing clothes of another form of dispute altogether. So, Article 10 would ordinarily surface in defamation, employment, disciplinary proceedings, judicial review, regulatory action, as well as commercial litigation, really. It is not usually the cause of the action, but the constitutional lens through which the dispute is viewed. So, for instance, as Judge Hisham has mentioned, the UKM4 case is actually a very apt example of what would have just been an ordinary, perhaps disciplinary proceedings. If the students did not look at it from the constitutional perspective, they would have just fought it directly from disciplinary action. Oh, there is actually a law. The law says this. We have breached the law. Are we guilty or are we not? And the lawyers could have also taken that straightforward approach. Instead, I would presume, the lawyers, they looked at it from a constitutional, they were very aware of the constitutional rights. So they looked at it from a constitutional lens. So rather than looking at it just from a straightforward disciplinary action, they said, look, this is actually a breach of our fundamental rights under the Constitution. So this case, I think, reminds us that constitutional principles can fundamentally change the course of ordinary litigation. So to the students here today, please do not think that constitutional law belongs only to the textbooks or to the federal court or the appellate courts. I would say that it is perhaps the most fundamental subject that you will study, because it provides the values which that underpins every area of your legal practice. Whatever field you eventually enter, whether in-house counsel, general practice, academia, and so on and so forth, do keep an eye for an opportunity to uphold these values. That's why I think constitutional law is always taught at the beginning when you're still fresh, before you get into the more practical and commercial subjects towards the end of your degree. But when you're fresh law students, budding law students, all these fundamental principles, I think, is very important, because you're looking at it with a fresh pair of eyes, so that hopefully all these principles will be embedded deep within you and carried within you throughout your career or your practice, as the case may be. You may not always, or you may never have the opportunity to argue a headline constitutional case. It's very rare. If you ask anyone, have you argued a case on Article 10? I think not many lawyers will be able to tell you, oh yes, I've argued that, and things like that. But if you actually ask them, oh, have you actually, looked at it from this perspective, or constitutional law and freedom of speech, they will say there will be more numbers. The numbers will actually be higher. So, but whenever you are when once you have graduated, do keep in mind these principles, so that you can then go ahead your career, defending fairness, like what judge says, proportionality, the rule of law, and freedom of expression, and then you can actually give life to the constitution. So Cik Nazim, don't feel jaded, because I do not think that constitutional law is just an airy fairy subject. I would disagree on that, because I think in everyday practice, even though I am a commercial disputes lawyer, whenever we hear clients, when we see cases, I think these are the entrenched principles that sits at the bottom of it. When we hear something like this doesn't seem right. We look at company law, we don't see anything in company law. We look at tort, we don't see there. We don't look at the contract side, it doesn't say anything. So where do we look? We look at the fundamental principles of law, which is our constitution, and the basic there. So that's my take of it. Sure.
Thank you, Ms. Farah. For those of you who don't know, Ms. Farah is an alumni here. Yes. So yes, she was
Can I
sitting
just
where you guys.
pause you there, Nisha? I was actually very impressed when I came here, because when I was a student, this was actually a dining hall. So this was a girls' hostel. I actually stayed in a dormitory down there. So to see the dining hall now turning into a mini auditorium is really interesting.
So 10 years ago, she was just sitting where you guys sat, and now she's giving a speech. So you guys can too in 10 more years. Hopefully at Ideas Partnership. Okay, done promote. Okay. Okay, the next question. So there's a saying that freedom of speech means the freedom to offend others, except the government. So now the question comes to the recent federal court decision of Hedi Kwa. Yes. So I'll pass the floor to Judge Hisham to answer his thoughts on his assessment of the Hedi Kwa decision. So Judge, the floor is yours.
Thank you, Nishal. One of the provisions in the Communications Material Act 1998 is the notorious Section 233, subsection 1A. This section has been used again and again and again over the citizens. More often, when a citizen is charged say under the Sedition Act, for uttering something that is seditious, you'll find in the second charge, section 233 1A. Yeah. So sometimes I think this provision has been abused by the authorities to suppress freedom of expression. Now, the case of Hedy Kwa. Hedy Kwa is a human rights activist and co-founder of Refuge for Refugees. In June 2020, at the height of the COVID-19 pandemic, she posted on Facebook about the spread of COVID-19 in an immigration center, reporting inadequate health and safety precautions and dangerously cramped conditions endured by detainees there. She was charged. She was charged under section. Now, she was not charged for of something that her report was not true. She was not charged for making a false statement of facts. Strangely, she was charged under the section 233 1A of the Commission and Multimedia Act, I refer to as CMA, for this is interesting, knowingly making and initiating the transmission of a communication which was offensive in character with intent to annoy another person. Hmm. Apa salahnya yang direport tu? Kalau laporan tak betul, you charge lah for a false report. But no, it's for interestingly for offensive and intent to annoy. So siapa yang felt offended and siapa felt not annoyed. But that was the charge against her. The charge against her, yeah. Now, section 233 1A is a very notorious provision. Statistics-wise, between 2020 and 2023, only 38 charges were filed out of 444 cases investigated under Section 23, which reflects a prosecution rate of merely 8.6%. So the authorities actually were not interested in a conviction. Only 8.6% convicted. They are more interested in charging. Okay? Charging. So that had the chilling effect. You know, when I'm sorry. In investigation, the charges were only 33 charges. The rest were all investigation. They were interested more in investigation. You know how you feel when you are being investigated? The moment the police come and say, come to this IPD, we need statement, that upon you die, tam tum. So to them, that is good enough. That is good enough to deter. They're not interested to charge and get the copy. They're not interested. So only 38 aja. Investigation 444. So that's what the section is used for. So in April 2022, the Sessions Court granted Hedy Kwa a DNAA. You know all what DNAA, yeah, DNAA, right? So she filed an ordinary summons in the Shah Alam High Court challenging the constitutionality of the words offensive and annoy in section 233, subsection 1, lim A. Offensive and annoy. Remember these two words, offensive and annoy. She says, her claims that why that this section is unconstitutional. Unconstitutional. Because as a exercise under the power to restrict is unconstitutional. Because why? Annoy and offensive are vague words. is not being clearly defined in the Act. What is offensive to A might not be offensive to B. What is annoying to A might not be annoying to B. And look at the power to restrict. It must be for purpose of public order, in the interest of public order. So how come public order is violated? How come public order is violated when what is uttered will only annoy A or B? It's not something that will annoy a group of people. So how can that be a violation in interest of public order, right? So that is her argument, and apply for the court to strike off, to strike off this particular section. And another matter, section 233, that provides for this word annoy, offensive, does not provide any standards, guidelines as to what amounts to offensive or what amount to an intent to annoy. So it went to the High Court. The High Court was not with Hedikwa. She appealed to the Court of Appeal. Now, the Court of Appeal accepted her arguments. So the Court of Appeal, such words as annoy or offensive are very vague. So if you want to restrict the citizens' right freedom of speech, you cannot restrict it with vague words, right? So she won at the Court of Appeal. But the authorities were not contented. They appealed to the federal court. The federal court ruled otherwise. The federal court ruled otherwise. The federal court says the words offensive and annoy are not unconstitutional. They do not contravene Article 10, Clause 1A, and it falls within the permissible restriction. The federal court takes a different view. The federal court says it falls within the permissible restriction of Article 10. Although the restriction law are not clear. It use vague words like annoy and offensive. However, the federal court says we upheld her acquittal. Her post was factual, opinion, and criticism on a matter of public concern protected by Article 10, Clause 1A. And so affirm the Hadith cause prosecution was unwarranted. Okay, we acquit you, but at the same time, the federal court says that provision is constitutional. Federal court was trying to save, it's constitutional. So how do I take the two judgments of the federal court and the Court of Appeal? In my judgment, I'm more in favor of the judgment of the Court of Appeal. The Court of Appeal asked the constitutional correct question: is there a rational nexus between the restrictions and its stated aims? Does it serve a legitimate aim recognized by Article 10, Clause 2, Lim A? Is it proportional? Are there adequate safeguards against abuse? The questions are plainly no on all accounts. the federal court pula in trying to save the provision says, when we enforce the provision, we try to see, was there an intent to be offensive? Was there an intent to annoy? Only kalau there is an element of intention to be offensive and intention to annoy, then it is a breach of Section 23. But you cannot expect the enforcement officers on the ground, bila dia nak enforce, nak baca the federal court judgment, how the federal court, it doesn't make sense. So, but the federal court was trying its best to save Section 203 from being declared unconstitutional. So that's it lah. That's it. Then the government realized the words are all very vague. You want to restrict the citizens punya freedom of speech. Your law that restricts must be precise and easily understood by the citizens. Yeah, you cannot have words, vague words that put the citizens in jeopardy. They don't know will they be charged or will not be charged because of the vagueness of the provisions. So the government amend the law and try with an explanation. How do you interpret offensive and how do you interpret annoy? Apa tu annoy? Apa tu offensive? But the problem is, in trying to explain what amounts to offensive, what amounts to annoying, the government again, Parliament again, use vague words. Yeah, vague words to explain vague terms. So result was a useless exercise. But yeah. So okay, thank you very much. That's my take on this question, right?
Thank you so much, Judge. They say Parliament does not legislate in vain, but it comes to this kind of acts, it seems to legislate in vain always. Okay, moving on to the next question to Encik Nazim. So Encik Nazim, we've already heard about the rights of freedom of speech and expression. We've heard bits and pieces about how government restricts this freedom. And one of the strongest tools that the government uses is always the Sedition Act. So we'd like to hear your take on the Sedition Act. Do you think it is constitutional? Do you think it is compatible with Article 10? What's your take?
Okay. Do we have a right to vote in a different government in a national election? Yes, we do. Could the government pass any law to compel us that, okay, in this election, you have to vote for this political party? If you don't vote for this political party, that is an offense. So obviously they can't do that. So in a conservative democracy like Malaysia, we have every right to vote in any politicians or any political party to form our government. So because of that, does it necessarily follow that we also have the right to kutuk these people? To say something bad, to criticize the politicians, the leaders of a government. So this is the issue whenever we discuss the scope and the context of Sedition Act. Um, um, this is made worse by so-called legal experts who have no legal background, who keep on advising people that you have to stay away from touching upon the sensitivity of the majority. I know because I met so many of these legal experts. Unlike you, they have not sat for any constitutional test. They have not. I think if they have sat for any of our tests here, they would fail hands down. Be that as it may, they have this utmost confidence to tell me this, you can't do this, you can't say that, because you are touching upon our sensitivity. Okay, I mean, it is made worse by that. People's understanding, they believe they know more about constitutional than we do. Okay, now, So this is a problem with Sedition Act. In reality, we could appoint anyone to be in the government. We could vote in any other political party to replace them. So because of that, why can't we say anything bad about them? Why can't we criticize them? Because that falls under Section 3, subsection 1. Okay. But however, when you look into Justice Raja Azan Shah's judgment in Ui Kisai, well, he allows criticisms against the government, but they're within certain limits. You cannot cause and you cannot incite them. You cannot incite the public. Even that remains vague. I believe that. So, what do you mean by you can't incite the people? I mean, if people hate this particular politician who is so corrupt, who is really knee deep in abuses of power, so could that be considered an incitement? We don't know. Okay. Next, from a jurisprudential point of view, it's the Sedition Act. You see that Sedition Act was Sedition Act 1948, and this was enacted in 1948. So in my legal history lessons, we always ask the student, so what happened in 1948? What happened in which the British had to enact something which is called Sedition Ordinance during those days? Okay. So in 1948, obviously, a lot of people in Malaya wanted British to leave Malaya because they've had enough of all of these foreign powers coming in and occupying this country. Look, we suffered enough during the Japanese occupation of Malaya. So after the war, we want a law which still exists right now, valid, regardless of its purpose, regardless of everything, because Article 162 says, yeah, it is valid. I could understand the logic of Article 162 because look, at the point of America, if you say that all the laws before this are not valid anymore, let's start afresh. So that would cause a total chaos in the entire legal system. So we needed those laws. But I draw the line if you say that, oh, you cannot say this is against mengacau sensitivity. Those are the exact words used against me. You tak boleh komen pasal UiTM dan perlembagaan. Ini mengacau sensitivity warga kampus. I was like, my answer is very clear. You cannot claim everything is protected because you feel sensitive about it. It has to be based on the law. So if you're saying that this is based on Sedition Act, which portions of Sedition Act? Obviously tak boleh jawab lah kan, because hello, me, bukan ni jawab. So yeah. Next, finally, you come to the decision of public prosecutor against Azmi Sharom. Okay, very very interesting decision. Within the first few paragraphs, that Tun Arifin was saying, a constitution. I mean, what was that? What was that case? Ikmal, really, the entire name was it? Orang Kaya Menteri Baginda. Menteri Osman Baginda. So so Tun Arifin Zakaria was quoting from that judgment. Look, this is a constitutional issue. In a constitutional issue regarding constitutional interpretation, there are two things. Number one, you cannot merely use judicial precedents. I mean, you cannot just follow previous cases. That would only work in statutory interpretation. So in constitutional interpretation, you don't really follow past decisions of this. Number one, and number two, also that part lah. A constitution has to be liberally interpreted. It cannot be rigidly, literally interpreted. Okay, so far so good. Okay. However, at paragraph 85, was it 83? Suddenly, there was a shift. However, previously in the case of Pung Chen Chun, the Supreme Court of Malaysia has already decided on this point whether any law is reasonable or unreasonable. That is to be decided by Parliament, not by us. So yeah, we hold that whether Sedition Act is reasonable or not, that's not for the court to decide. That's Parliament. Question. Wasn't that referring to judicial precedents? Yes, kan? So in the first few paragraphs, the court was saying, oh no, judicial precedent plays a lesser part in constitutional interpretation. Okay, so far so good. Tapi in paragraph 80, was it 85 or 83? But however, previously the court in Pung Chen Chun had already decided whether a law is reasonable or unreasonable. That's for the parliament to decide, not for the court. Bukan ke itu judicial precedent? So be very careful if you have to use the decision of Azmi Sharom in a matter regarding Sedition Act. Okay. Looking into the trend of cases, especially the 3R cases, I would like to bring your attention to the federal court's decision in Kapal Singh. Remember Kapal Singh, charged and convicted for sedition because of his statement regarding the Perak constitutional crisis. So Kapal Singh was saying the powers of the Sultan of Perak was limited. It wasn't absolute and so on. Somebody lodged a police report against him under sedition, so charged, convicted on sedition. 5 years after he was passed away, the federal court then overturned the decision of Court of Appeal. Court of Appeal dah kekalkan he was guilty. When it went to the federal court for appeal, this was 5 years after Kapal Singh has passed away. The federal court found the Court of Appeal made a mistake. The Court of Appeal did not consider the defenses under Sedition Act. So clearly, if you really want to be safe, especially in 3R areas, always look at the defenses under Sedition Act. So here, regarding the powers of the Malay rulers, I'm sure you are really following what's happening in Johor right now. So to be safe, okay, number one, shut up, don't say anything. Number two, if you need to comment, under the Sedition Act, under the defenses, is that if you want to say something because you want to alert the ruler that that he has been misinformed, that the law is like this, however, he has been informed, blah blah blah, and that's fine. Sedition Act allows that to be used as a defense. Other than that, you cannot use the defense of, oh, tapi I only wanted to educate everyone. No. Look, under Sedition Act, Section 4, intention is not relevant. So that's Section 3, Kak Lin. Section 3, sorry. Section 3, yeah. Intention is not relevant. No matter how noble your interpretation is, you are caught under you're caught under that. So be very, very careful. Okay. Is that all? Okay. Thank you.
Thank you. That was a very comprehensive lecture summarized in just a few minutes. Thank you, Cik Nazim. Okay, the last question before we go to Q&A will be posed to Ms. Farah. So, Ms. Farah, in disputes involving freedom of speech, it almost always intersects with other areas. And this includes defamation, employment, administrative law, and disciplinary proceedings. So even if I want to gossip, also my kena, So from a litigator's perspective, how do you identify the most appropriate legal strategy when constitutional rights overlap with private rights? And what are the considerations?
Thank you, Nishal. I think from disputes perspective, what we usually do, as I mentioned earlier, is that when clients will come to us with problems, so we ask them, okay, this is your problem. What is it that you want? Really, some clients will say, I'm hurt. Maybe the university has made this has infringed on my rights. It has affected my business and things like that. So from there, you then formulate your legal strategy. Okay, you have a business. The government you've made a statement online. That statement has gone viral. Government has taken action against you. So which of it do you prioritize? Is it your business? Is it your reputation? Or is it the government actually restraining your rights to actually make further comments and, charging you under Sedition Act or, other acts and things like that? So we then prioritize, and from there we then formulate the legal strategy. So once we see that and we say, okay, some clients are very upright. They'll say, I want to go everything. So we say, okay, then we fight everything. We put in the constitutional point, that all these actions. So we might take up a So the litigation strategy could be multi-pronged. It's not just one legal action. It could be one action under contracts, could be one public law action where we take an action against the government for an irrational procedural irregularity or unreasonable decision that they have made. If they come up, if sometimes clients will apply for a license and they say, no, we're not going to give you a license anymore because you keep on making all these kind of statements. So no more license for you. So we challenge that license. So I think as litigation, as law students, that's what you always have to keep in mind. All these fundamental issues on constitutional and rights. So when you look at something, you know that, look, this is actually what we can do, and you're not just focus only on one area. Oh, this is just defamation, or this is just contracts, this is just your business loss. But it actually goes beyond that. And sometimes when you think about litigation from that overall perspective, it would actually help your case, because maybe your commercial case is not very strong, but the constitutional point is actually something that would help you, actually win your commercial point, because that actually lends strength. Your judicial review action actually adds strength to whatever commercial negotiations that you are facing, and we do this all the time. So that's what we call strategic litigation, not just one angle litigation. So we look at it from a holistic point. So I think that's what's very important, and I think I'll keep my answers very short and simple. So to law students, I think that my takeaway for you all will be, in as much as maybe sometimes some subjects to you in law school may not make much sense. Why are we studying this? It seems so abstract. But trust me, when you're in practice, all of this will actually come in handy. I think when your lecturers, the dean, come together to actually formulate your syllables, they've actually put careful thought into what you should learn to actually equip you for the real world, so that you can actually see all these things. It's just a matter of whether or not, one, you actually see it, two, you get the chance to apply it, or you opt to apply it. Because like Judge and Chin Azim say, sometimes the law is there, but most people become complacent. They become very afraid. They don't want to challenge the law. Tak apalah, biarlah. This is just our college. It's pasrah, reda, and things like that. So is that the kind of attitude that you want to bring in? So I think as law students, just like what Judge Isam say, when the 4 UKM students actually fought to challenge that legal the provision in the University Colleges Act, we are also the future in terms of custodian of the law, in terms of how we choose to argue and how we choose to advise our clients, or how we choose to advise our organization that we work in. Are we going to tell our bosses, if you're in a company, and say, tak apalah, let's play safe, let's not challenge? If you do that, then administrative law is never going to evolve. No one is going to file a judicial review application against the government because they're scared of the consequences. No one is going to challenge the constitutionality of a provision because they're scared of the government, of the backlash and things like that. So that shouldn't be the case. And I think for me personally, I'm proud to be part of RDS, where my partners, Judge, we're not afraid to challenge the law. We're not afraid to go against the conventional thinking. As it is, our consultant is also going to court and challenging the Malaysian bar's decision on certain interpretation and certain act and things like that. So I think this is very important. And you need to take this wherever you go, whether you're in a legal firm or an in-house counsel. Do not just accept or play safe, because that way, number one, you will always be restricted and confined, which I think will be is such a waste. It's a waste of time for you to go to law school and learn about all these beautiful, fundamental concepts, if you're just going to adhere by it and play safe all the time. When you challenge the law, you don't just develop and help your clients, but like Judge says, sometimes you lose. But then the government realize, oh, we've done something wrong, let's amend it. And they still get it wrong sometimes. That happens so many times. For instance, I've argued a case on the Money Lending Act. They had to amend it so many times because they can't get it right. So this happens, but it takes law students who becomes lawyers, or who becomes clients, to actually have um, that tenacity and that willingness to want to test. When a provision is vague, when a provision doesn't sit quite well, and you know that it's not right, it doesn't sit within the corners of fundamental liberties and things like that, do not be afraid. Go within the law. Like Chin Azim say, the law says this, you see the law, we challenge it. We challenge the interpretation, or we challenge the execution, or we challenge the procedure. So that's how I think all of you as law students and future practitioners should actually approach the law and what you learned. So it's nothing is a waste in that sense. Hope I didn't go astray with that. So yeah, that's it.
Thank you so much, Ms. Farah. So essentially, the bottom line is this: don't just accept the law as it is, but accept it as how it should be. And for a fun fact, even though Hilman Idham challenged the government, he's still now a member of state assembly. So even if you go against the government, you still have a bright future. Okay, so let us go to the Q&A session. So the floor is open to anyone who wants to pose any question. Please state your name and then state your question. Anyone? Yes. Huh? Yeah.
Assalamualaikum. My name is Muhammad Moyarabi. 5 students. My question is this, perhaps to Judge Lando Shamrid. As a way forward as a nation, fundamental liberties as values, the people values is important, not just skyscrapers and everything for us to be a developed nation. And by drawing comparison to like Singapore, I think all panelists can agree that Singapore has much more stricter enforcement on this freedom of speech. So my question is it necessary for us to really like go into and challenge this restrictions that have been put on us regarding freedom of speech when we compare that Singapore actually is doing fine and they are developed nations as compared to us? Last time I checked, we're still developing. And is it really important for us to actually become a developed nation by challenging this freedom of speech things? And what is Datuk Syamuddin comment on that?
Thank you for the question. I'll begin with Singapore first. Yes, true. Singapore is in a way is authoritarian. Yeah, you don't have that freedom of speech there as we have here. But Singapore respects the other rights of the citizens. Respects. Number one, there is hardly not much of corruption in Singapore. The government really abhors corruption, and there is no room for corruption in Singapore. That's why the country is very progressive. They really very strict about corruption. Tak macam kita kat sini. Yeah. Right. In Singapore, if everyone is equal, so that's human rights, everything is equal. You apply for something, you apply kata for a right to a housing in HDB housing, dekat Bedok kan, you apply, there is no queue cutting. There is no such thing as, you can pull a cable, you get it, you don't have a cable, tak dapat. In Singapore, that is the rights and respect of every citizen. Yeah. So there is equality. So nak katakan Singapore tak ada human rights, dia ada human rights. But in other aspect. But the only thing they are not very they're very concerned is do not attack the leadership. Yeah. You attack the leadership, yeah. The government will be hard on you. But in other aspects, the government respects your freedom of speech, respects your right to equality, to the wealth of the country. You work hard, you can be rich. Yeah? So that is Singapore. Now, why must we respect human rights? To me, my personal view that in order for every nation to progress, the citizens must enjoy human rights. You must give them the freedom of speech. the right to peaceful assembly, right of association, equality before the law, and etc. etc. The right to hold properties, because these are all human values. We must uphold human values. And in a nation where human values in the form of human rights are not upheld, the nation will feel subdued. Kan? Kita lemahkan semangat mereka. So that's why in order to progress, we must respect the human rights of the citizens. And even in countries, foreign countries, kalau dia nak invest in our country, dia tengok dulu kita punya stand of human rights. If there is a lot of exploitation in the country, kan, we exploit our labor, then we don't give them human rights, they will be very reluctant to invest in our country. But if they study our country, they tengok, oh, Malaysia, there's a lot of respect for human rights. So there are the incentive to come and invest in this country. They find that our laws are fair. When we enforce the laws, we don't keep on changing the goalposts. We keep on changing the goalposts. Sekejap boleh, sekejap tak boleh. Kan? Then they won't come. They say, oh, that is not a place to invest. You will go other place. We'll go to Indonesia. We'll go to, Thailand and all that. So that is my take on why fundamental rights is very important. That is human values, right to equality. How can we do away with right of equality? Right of equality, right is justice. Is a part of the rule of law. Right not to be discriminated. Yeah, that is very important. Yeah. Do we want a nation where berbelah bagi because we have racial discrimination against race, discrimination against religion? At the moment, we have to do something in our nation. Don't you feel that after so many years of independence, are we forging towards unity? Sometimes I rasa after many years of independence, the population of this country, we are not getting closer to unity. We are more, going further and further away. So this is something that we have as citizens, we have to think about. Yeah, we all must strive for racial unity, for racial equality, right? Yeah. Okay, thank you, Brad.
Yes. Encik Nazim?
The right to housing, for example, in Singapore, has been argued to be a lot better than what Malaysians enjoy in Malaysia. If you were to compare your flats or apartments in Malaysia and compare that to the HDB flats in Singapore, jauh beza. I mean, allegedly, this is what people say. Because Singapore, from the times of Lee Kuan Yew, fully ascribe to the fact that Singapore steadfastly refused to follow the Western concept of human rights, which is based on individual rights. Singapore believe that communities' rights, the rights of societies, duty of the individual society, those are far more important than individual rights and so on. And yes, Singapore is very authoritarian. If you have to read the book of written by Jyoti Raja, for example, she wrote on how the brand the brand of constitutionalism in Singapore is known as authoritarian constitutionalism. Okay, be that as it may, those of you from JB who clogged up your roads during the weekend, Singaporeans. Those of you from Melaka, siapa yang take up a lot of spaces dekat tempat ikan bakar kat Serkam Pantai on weekends? Singaporeans again. Those of you from Kelantan and Terengganu, if you notice, kan, every time school holidays in Singapore, who sent busloads of their students to do snorkeling in Kelantan and Terengganu? Again, Singaporeans. Again, because I've been told this. This is what I would say. I'm not sure the contradiction of life or whatsoever. Singapore could boast they have a great economy, first world country, and so on. But at the same time, I wouldn't want to live in Singapore. With all the faults that we have, you know, and yes, as pointed out by Dr. Ishamuddin, there are faults here that you cannot ignore and you cannot disregard. But it's like that. And the thing is, um, was it in 2022, I was invited to a seminar in NUS Singapore. So and after that, I vowed to myself that I would never return to Singapore ever. Okay, number one, dah lah mahal. Okay, a plate of nasi lemak costs about 10 Singaporean dollars. How much is that? RM35. Hello. Number one. Number two, everything felt fake and contrived in Singapore. Very fake. People were rushing and people were really into money, 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 money. Nothing to, nothing like this. Whatever gardens of the bay or whatever public gardens they have, you know that those cannot beat our hutan taman negara. So I'm, you know, regardless of the standard of NUS is one of the top universities in the world. I mean, yeah, you could enjoy that, but you know, I'll live and die in Malaysia. So, thank you. Good job. Sorry, one more point. Okay. Unfortunately, you cannot disregard discriminations in Singapore. And there are two books if you're interested in the so-called, not so-called, really discrimination that the Malay community faced in Singapore. There are two books. And both of these books are published under Oxford University Press. Book number one was written by Tanya Lee. Okay. According to Tanya Lee, during the early days of Singapore, because there are many Malays serving in the security forces in Singapore, dalam polis and tentera semua tu. So in the early days of Singapore, the Singaporean government refused to renew the contract of service for all of the servicemen. Okay, for some weird reason. Orang lain they renew the contracts apa semua tu, but not for many of the Malay servicemen. So when you're Malay, you've been serving in the security forces in Singapore, that is zaman British semua tu, suddenly you lost your job. What happens? Unemployment, poverty, and so on. But that's number one. Number two, when you read the book written by Lily Zubaida Rahim. So Lily Zubaida Rahim pointed out, National Service, bukan macam you all punya holiday free PLKN tu ya, bukan. National Service in Singapore, you have to do it for 2 years at least. Now, in the early years of National Service policy in Singapore, Melayu tidak dipanggil. And then you know that if you don't serve in the National Service in Singapore, what happens after that? No businesses would employ you. So this has been repeatedly questioned, and there has been no answer from the Singaporean government to admit that the adverse consequences of this policy. Malays were left out. So that again contributed to the cycle of unemployment and poverty and social problems like crimes in the Malay community in Singapore. And these are recorded in these two books, again published by Oxford University Press. Okay, sekian terima kasih.
Can I just add one thing, Vishal? I think in terms of comparison, I don't think it's fair or apt to actually compare Singapore and Malaysia. It's not comparing apples to apples. As a mom, my answers to my children is always very simple. They will tell me, how come that my friend can do this and my friend can do that and I can't do that? And I say different houses have different rules and different ways in which. So what I do in my household and how and things like that may not work in others. So I would say that just because there appears to be less challenges to perhaps fundamental issues in Singapore legally does not mean that, we should not be doing that if we're looking at to being a developed nation, because there's so much more quality or quantitative factors that we should be looking at if we're looking at being a developed nation. And challenges to law, I would say, is just one of it. Singapore may not have had many challenges, but I think if you look at the history in the UK, in America, they go to courts on various issues, and it's not complacent. So what works in Singapore is, I think, very unique to the Singaporean history and things like that. That would take, I think, a lecture on its own. But I think in Malaysian context, we have a fairly healthy legal and fairly healthy and fair legal, establishments. We have the courts and things like that. So if the law is not right, or if the government comes up with something that does not make sense, why can't we as citizens actually test the law? We may not win, or we do, but even if we don't win, we see that the government will actually try to amend the law and things like that. So I think we should look at it from perhaps from that context, and not just from a context of, wait, they don't have to challenge, and why are we worrying ourselves so much about this kind of issues? Because our issues are very different, I think. Thanks, Nishu.
Okay. Thank you so much, Ismala. So basically, Singapore good may not be as good as Malaysia and Char Kway Teow. Okay, right? Yes. So sorry, as a Penangan, I cannot ignore this statement. Need to mention. Okay. I think we don't have much time, so I'll just ask each of our panel just to give one last statement or any advice you have to the students before we end, and then we'll close our session for today.
I start first and
Yes.
give the last two.
Judge, yes. So we start for Encik Nazim, Ms. Farah, and Judge.
All right. Now, throughout the world, students have always been feared by governments. University students have always been feared by governments because you have huge power to effect changes, social changes especially. In Iran, for example, in the revolution of Iran in the 1970s, the students stormed the businesses owned by American companies and even stormed the US embassy and so on. So the downfall of the Shah government in Iran was also due to the participation of university students. Next, for example, the downfall of Suharto in 1998 was also due to the activism of university students in Indonesia. So don't play with university students. Okay. Next, in Mao Zedong, China, in the 1960s, I think, in their Cultural Revolution, university students in China were influenced to fight to defend the ideals of Marxism, and of course to defend the political expediency in the interest for the personal interest of Mao Zedong. So again, and of course we've seen in Malaysia in 1970s the movement of university students here. So don't play with university students. Okay. On your part, on the part of university students, especially for law students in UiTM. Number one, law is only taught in our faculty. Law is not taught in other faculties. No matter what you are told by some of these legal experts from other faculties, you are the only ones who do law. You are the only ones who study law. So you must know what the law is inside out. Okay, I've seen enough of students and lecturers on other faculties trying to tell us what the law is. No, so that depends on us. You as members of the law faculty, you need to know what the law is. You need to know what the cases say. That's your job. Next, whatever you do, because what? You are not secondary school students anymore. So you have to face the consequences of your actions. So I'm on the part that I cannot. I belong to the group that I do not want to control the students. I mean, you are university students. You are not school students anymore. So I cannot treat you like your secondary school students. But at the same time, you have to show and prove that you are not secondary school students. Which is why kalau Kak Ling dan Dr. Iqmal suruh baca kes, baca tak? Baca tak? Bila dah suruh buat assignment, chat GPT lagi ke? Yeah. After you've gone through all that, then you get to say, oh, we are university students, we know this is our right, and that's fine, go buatlah whatever. Buat itu dulu. Then you could, other than that, yeah. Right, thank you.
Thank you, Chin Azim. I think this, I mean, historically, like Chin Azim says, a lot, I mean, university students have always been at the heart of many revolutions around the world and made history. We in Malaysia we have been very blessed, even though with changes of government and things like that. They say political instability, but things are still stable because we still have enough food, we still have roof over our head, so we have not really taken it out to the streets. I mean, there have been a few, Bersih and things like that, but it's not so bad. The situation is not so bad. So I think my key takeaway would be don't take that for granted. Please, as law students, we all of you are actually privileged to learn this as part, to be exposed to all these ideas as part of your curriculum. Fundamental liberties, justice, fairness, and things like that. So my hope is that wherever your careers will take you, that you will never lose the courage to stand up for all these principles, justice, humility to keep on learning, and the wisdom to remember that the law is ultimately about saving the people and everything around you. So if you do that, I think you will not only become good lawyers, you will also help in your very own way, wherever you are, to build a stronger legal system for the generation that follows. That's it.
My advice is do take the subject constitutional law seriously, right? Do take constitutional law seriously. Even if you think that later on in life you are not going to be uh, 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 um, an officer in the Attorney General's chambers, or you are not going to, or say, be a judge, do take your constitutional law seriously. Even you think that I'm going to be a commercial lawyer, I'm going to be a law teacher, I'm going to do business and not, but still do take your constitutional law seriously, because knowledge of constitutional law is very important in life. Yeah. Or whatever you do, if you were to read what happened throughout the country, the daily happenings, everything has got a constitutional law dimension. Yeah. So if you take your constitutional law seriously, then you will have a greater appreciation of what is happening. Yeah. And everything in the current affairs has got a constitutional law dimension in that. So my advice is do take constitutional law seriously, right? And the other thing is do strive to develop critical thinking. Always questions. Never takes things for granted. Always question: is this right? Is this not right? So always develop a critical thinking um, while as a student or when you are later in life. Later, when you have graduated, whatever profession you take, do it well. Do it well. If you are uh, a lawyer, say to yourself, I'm going to be a good lawyer, right? I'm going to excel as a lawyer and respected by my peers. If you're going to be a law teacher, you say to yourself, I'm going to be a very good law teacher. Okay? So that's my advice. Lah. And with that, I wish you all the best in your studies. Exams is coming around the corner. Do try to excel, yeah? And get first class or second class upper, something like that. All right, thank you. Okay, bye.
Yeah. Last thing, just to say, on behalf of Adia's partnership, thank you so much to the Faculty of Law UiTM. And thank you so much to the students for coming today. Okay, thank you.
Ladies and gentlemen, we have now come onto the token. My apologies. Thank you to fellow audience for those thought-provoking questions, and also big thank you to our panelists for answering it. With that, to our distinguished panelists and moderator, you may now return to your designated seat, guided by the ushers. Ladies and gentlemen, I would like to thank once again to our brilliant moderator and panelists for an incredibly stimulating discussion on fundamental liberties. Let us now give them another round of applause. We have now come to the token of appreciation session. To present these tokens on behalf of UITM, I would like to invite Associate Professor Dr. Noor Izan Rahmat to present the plaque and tokens of appreciation. To receive the plaque and tokens, we are honored to invite Yang Berbahagia Datuk Seri Muhammad Hishamuddin Yunus. Once again, we would like to invite Yang Berbahagia. My apologies. Next, Yang Berusaha Puan Farah Syuhada Razali. Next, Yang Berusaha Encik Muhammad Nazim Ganti Syari. And finally, we invite our moderator, Mr. Nishuldran Ravindran. Thank you, Dean, for the session, and we kindly request for Associate Professor to remain on stage. Now, for our next presentation, I would like to kindly invite Yang Berbahagia Datuk Seri Muhammad Hishamuddin Yunus, representing RDS Partnership, to present a token of appreciation to Yang Berusaha Associate Professor on behalf of the firm. Thank you very much to Datuk Sri and Ardeen for the token of appreciation. We kindly request and invite our panelists and moderator and guests to take the stage for the photography session with the audience. You may now take the stage for the panelists and the guests. I also would like to invite the audience to stand up and fill the gaps in the middle for the photo session with the VIPs.
Okay, stand by. Okay, right. One, two, three. Again, one, two, three. All right, freestyle. One, two, three. All right. Right, okay, again. Okay, stand by. Okay, one, two, three. Okay, again. One, two. All right, freestyle. One, two, three. All right.
Ladies and gentlemen, that brings our formal program to an end. We would like to express our deepest gratitude to RDS Partnership, our faculty leadership, and our brilliant speakers, and all of you in the audience for making this event a success. We now cordially invite all of our guests and panelists to proceed to Lounge 2 for the tea session. As for our fellow students,